You were in an accident, your life has changed, now the insurance adjuster doesn't want to give you a fair offer. Okay, what are the things you can do? Hi, my name is Shane Smith. I'm the owner of Shanesmithlaw. I'm going to answer some of your questions. When an adjuster makes an unfair offer, how does an attorney fight back? One of the things we do is we negotiate with them. We can do that in a couple different ways. The first one is just, casual negotiation. We talk to them, send letters, things like that. Another option is to go to litigation, where you actually file a lawsuit. And third option is sometimes based on how unfair the offer sounds, the lawyer may look at doing something what's called bad faith litigation, okay, which is an extra type of litigation. There's some extra steps associated with that. One of them is you satisfy certain requirements, and the insurance company may be in trouble for basically proceeding unfairly, which may entitle somebody to extra damages. It doesn't happen all the time, but it's an option that may be there in cases that really a jury would consider blatant, okay? When a jury would look at it and say, wow, the insurance company really did treat you unfairly, and they were doing it on purpose. Now, usually that comes about when you have somebody who's injured very, very seriously, and it's a lower insurance policy. For whatever reason, the insurance company won't offer that policy. Okay, maybe instead of offering it, they offer half of that money, or they're making an offer below the medical bills or something like that. That can sometimes trigger an attorney to investigate is bad faith there or not. What happens when we have to file a lawsuit? And that basically begins the litigation process, okay? That's the first step in the court process, like you see on TV, that leads towards a trial. So by filing the actual lawsuit, the complaint, and the summons, we file that with the court, and then a copy of it is given to the defendant, the one who caused the accident. That then triggers discovery, which is where we ask their defendant a bunch of questions and ask them to produce documents that would help us. They in turn will ask our client or the injured party very similar questions. They want to know in the background, like everywhere you worked, injuries you've had, any arrests or convictions, but basically dig into the nuts and bolts of the injuries and how you got treatment and where the treatment was at and what your injuries are like. But also in your past, did you previously have any injuries? If there's any lost wage claims, they're going to ask to see income tax statements, things like that also. That's the discovery process. The next step is a deposition. Generally, on the plaintiff's side, we'll depose the bad guy, the one who caused the accident, and their insurance company will also depose our client, the victim. And that's like you see on TV, where there's a table, there's a court reporter who used to be typing, now they mostly talk into a machine. Their lawyer's on one side, we're on the other side, and everybody's asking the person questions, okay? After that happens, usually there will be what's called mediation. And mediation is really where everybody gets together and talks and negotiates and sees if they think they can settle this case without going to court or to trial. If that fails, then you've got the trial, okay? That whole process generally is going to take somewhere between 1 to 2 years. Sometimes it can be compressed a little bit faster than that, but usually 1 to 2 years. A lot of that is waiting after the discovery process is done, just waiting for a court date in front of the judge, okay? Once that happens, there's not a lot we can do to push that process along. What we can do is make sure we push through the discovery process in a timely manner. That process alone usually takes about 6 months. One of the questions I get asked too is, once we file a lawsuit, does that mean I have to go through the whole 2-year process to get in front of the judge? The answer is no, we don't. Sometimes, anytime during that process, the insurance company might increase their offer, or for some reason, the plaintiff might decide to accept their offer. And if so, then you can just call in. If that offer is still on the table, you can accept it, settle the case, or if they make a better offer, you could, as the plaintiff's attorney, choose to accept it. Or you could go to mediation. Mediation doesn't have to be done when discovery is over. It can happen at any point in time, but usually that's when it takes place. But a mediation case is resolved all the time. That's the point of mediation, is to try to resolve a lot. And a good mediator can help with that. All of this is really why you need an experienced personal injury attorney by your side to help walk you through that process. It's just something we've done, thousands of times at my firm here. This is what we do. This is all we do. Hit like and subscribe down below for other personal injury tips. Remember, if you're in pain, call Shane, 980-999-9999.
980-999-9999. 980-999-9999. Shanesmithlaw. In pain, call Shane.